Next to be interviewed, Your Honors, is Court of Appeals Associate Justice Apolinario Bruselas Jr. Justice.
Good afternoon, Justice Bruselas.
Good afternoon, Your Honor.
Okay, we will now start the interview. May I request Attorney Cayosa to start?
Thank you, Justice Gutierrez. Good afternoon, Justice Bruselas.
Good afternoon, Your Honor.
We have extensively interviewed you twice for the position of Supreme Court Associate Justice in 2011 and 2014, and for the position of Sandigan Bayan Presiding Justice in 2013. And as you know, the JBC conducts a survey as to the reputation and abilities of our candidates. So I take this as an opportunity to inform you of the reactions with regard to your application, both positive and negative. So let's start with the positive. It states here that you are principled, uncompromising, upright, and dispenses justice without fear or favor. You are an innovator and was instrumental in the design and successful implementation of what is the current case management information system of the Court of Appeals. That's on the positive. Now, we take this also as an opportunity for you to respond to the negative reports or allegations made against you. As in 2011, there was an opposition filed by Attorney Eligio P. Malyari against your application, raising the same grounds.
Yes,
Would you
Your
care to respond to this? I believe you have been given a copy of his
Yes, Your Honor.
opposition, and you have also submitted a letter to Attorney T. Capacite. But for the record, would you want to respond to it?
Your Honor, very briefly, this opposition, Your Honor, is sourced from or originated from a complaint filed by Attorney Malyari concerning a case where he was a party. And this case is a case where he lost in the case of the Court of Appeals, a certiorari proceeding. And this was a case which was decided by Division of 5, where the voting was 4:1. And then there was a complaint filed against me as a result, because I happened to be the ponente. I wrote the decision for the court, signed by 4 members of the Division of 5. And later on, there was a complaint and there was a motion for inhibition. I inhibited, together with the others who signed with me, and another Division of 5 was constituted. And it turned out that that Division of 5, with new members now, except for the remaining member who dissented and who did not want to inhibit, again turned out with a 4-1 decision. Actually, this case, Your Honor, should have been brought up by Rule 45, but I do not know, it was not brought up by the party concerned. Instead, the party wanted the Court of Appeals to look at it again, this time by the regular First Division, which is unprocedural. But in any event, Your Honor, this case, the source of the opposition, has been dismissed by the Supreme Court in 2011. And despite the attempts to keep the matter alive, these motions have all been successively resolved in the negative by the Supreme Court. I submitted a written report, a written response with the attachment of the Supreme Court resolution, and I did not anymore attach the other numerous resolutions, all denying the revival or whatever of the movement's desire. So the opposition really, Your Honor, is based on a case coming from a sole litigant. That is the long and short of it, Your Honor.
I believe that this was the same issue raised in 2011.
Yes, Your Honor, the very same issue. And until now, it's still being raised against me. I cannot help it that some people, one, would take it so sorely against me. It's just unfortunate, Your Honor, but the records will bear out that there is nothing there other than being professional about the matter.
There's another report on an allegation that the ATM card of your staff is being quote-unquote captured.
That's not true, Your Honor. We have an ATM cards. I have 4 lawyers and 4 non-lawyers, my utility and my driver. All of them have their own ATM cards. I have an executive assistant. My son is a coterminous 1. We share the same card. When they open the accounts, my son and my driver and my utility, they all open at the same time, and we all have what you call a joint accounts. They are not captured at all, Your Honor.
Sorry, who has joint accounts?
Me, my son, my driver, and my utility aid. When we opened the accounts at Land Bank, way before the ATM was operationalized, we opened accounts already.
Oh, I thought that is this for payroll?
It's now for payroll because now we are using the ATM for paying our staff. But all of our payments go to the ATM accounts, and my staff are paid, except for the three others that I mentioned: my son, my driver, and my utility aid. All of the payments are drawn by them directly. The three others, they can draw their pay from the ATM. They have their own ATM cards also.
So now, does your driver have his own ATM card?
They have their own ATM card.
So, but at one point, it was a joint account. You're saying?
Until now, it's joint, Your Honor, because what happens is, it's joint. We never close the account. It's still joint. They have access to the account. If the allegation is they are not paid, then that is something that's very, very deniable. They are paid. In fact, I pay more my utility aid because I'm using also as a driver. I give him more. So if that is the purpose of the allegation that staff members are not being paid, that is very, very untrue, Your Honor.
But wouldn't it be more prudent to just have separate accounts?
That should be correct, Your Honor. But as I said, when we started before the ATM payrolls, we already have joint accounts with the three of my staff. Only the three. These are personal staff. But if your suggestion is that they should now be separate, that's well and good, Your Honor. We should now separate. We have not had the time to have a separate account for only the three.
Thank you, Justice.
Yes.
Now, with respect to the CMIS,
Yes, Your Honor.
I understand that the other offices of the Court of Appeals already have the raffle of cases
Yes, Your Honor.
electronically.
That's
Have you been
correct.
able to adopt the same procedure here in Manila, in the Manila station?
Well, actually, Your Honor, I have been also pushing our PJ to adapt this in Manila because in Rian de Oro and Cebu Station, we already have electronic raffle since 2 years back. We have the same program, the same mechanism for doing that, but I think our PJ wants another feature added for the CA station. That's probably why he until now, he is of the view that we should not yet employ the electronic raffle in Manila. But if you ask me, Your Honor, it can be operationalized even now or even tomorrow because the same program is available.
So is that part of the CMIS system? I mean, like the ability to conduct an electronic raffle. Is it a feature that you could actually add as part of the system?
It is a feature that's already in existence. It is existing in Rian de Oro and Cebu Station, except that in Manila, we have not adopted the electronic assisted raffle. We are still doing the manual raffle because our PJ wants an additional feature incorporated into that electronic raffle program. And this is under USAID assistance, and as of now, USAID is concentrating on the e-courts project. This feature which our PJ wants to be added will be considered this year, Your Honor. But that is beyond my duty, beyond my responsibility to be able to enforce that. Right now, we have in the Manila station of CA electronic raffle. It's a PJ's call, Your Honor.
Justice,
Yes, Your Honor.
you are very active, no? Especially when it comes to training of judges.
Yes, Your Honor.
And I suppose you also very you closely coordinate with the members of the academe. What would you recommend if you become a member of the Supreme Court to improve the system by which we train our future lawyers? What would you want to highlight in order to make them more competent and more upright?
Well, insofar as having better judges is concerned, Your Honor, I think we have in place already the program which we call the pre-judicature program. I think that's a good program, except that it has to be improved further. Right now, I think it is not implemented in a way that all who would want to be judges get the training that should be given them. So that's one point, Your Honor. We have to improve the pre-judicature program. Then later on, when they are appointed as judges, we have to have what we have is an orientation program, which lasts for about 5 days to 10 days at the most. And I noticed that in these orientation programs, what the subjects that are taken up are mostly a review of substantive law. My position is that we should spend more time of the 10 days that are allocated, at least half, if not more than half of that, should be devoted to trial management, handling of evidence by judges, and actually, Your Honor, because it should be devoted to better trial management. How to craft that, what kind of program to put in place will have to be thought out by training staff. But to me, because it's important to have good judges at the trial courts, with good judges, we will have less appeals going up the appellate courts, because the litigants would be generally satisfied with the decisions. If you do not have good judges at the lower courts, we will have more appeals going up. So those are 2 points, Your Honor. Post-appointment and pre-appointment and post-appointment. We have to look at the training programs that are being right now dished out to our judges and prospective judges.
That was my final question, Justice Bruselas. Thank you, and I wish you well.
Thank you also.
Thank you, Justice Gutierrez.
Thank you so much, Attorney Cayosa. And now may I request Attorney Mejia to continue.
Thank you, Madam Chairman. Good afternoon, Justice Bruselas.
Good afternoon, Your Honor.
We have interviewed you no less than 3 times, at least during my stint here. And the few questions that I have for you have been addressed earlier by Attorney Cayoso, so I will no longer have any question and defer to Attorney Guevara. Good luck, Justice Bruselas.
Thank you very much, Your Honor.
Thank you. Thank you very much, Attorney Mejia. May I request Attorney Guevara now?
Thank you, Madam Chairman. Good afternoon, Justice.
Good afternoon, Your Honor.
Justice, I'm quite bothered by the reputation that the Court of Appeals has recently gained. The reputation that TROs are for sale at the Court of Appeals. Do you have any personal information as to the truthfulness of these reports?
With respect to having a personal information, Your Honor, I must say that I do not have any personal information. In the sense that I have not been able to deal with such an factual situation.
But
there are indeed reports. There are indeed reports that TROs are for sale, and we in the Court of Appeals are also very saddened by this. What I can say, Your Honor, is it is our duty, if ever, as a member of the court, if ever we encounter such a situation, it's our duty to report that, and not only to report. Under the law, we're supposed to initiate the proper complaint about it. It's just unfortunate, Your Honor, that truthfully and personally, I have not encountered such. Nobody has come up to me to say that, for this matter, we would like to have a TRO. In my own case, Your Honor, you can see the records. I have not issued a TRO. In the last 10 years, I only have issued about 3 TROs, Your Honor. And these are all TROs which eventually led to a decision in favor of the applicant.
Has the leadership of the Court of Appeals done anything about the matter so that the said unpleasant reputation of the Court of Appeals is removed?
As a member of the court, Your Honor, I can say that we have an ethics committee which is supposed to look after, to address these things. It is actually the PJ's job as the leader of the court to be able to hammer out and pursue a more robust response to these allegations. I remember that we have the last one that we have is that thrown out by Senator Trillanes, and that matter was referred to the ethics committee. I have yet to find out what the status is of that. I do not know, but that's the last one I heard, Your Honor. Of course, there are other reports about cases concerning TROs, but as I said, Your Honor, personal knowledge I do not have. It's really bothersome for someone, the Court of Appeals, for us, to be always met by that TROs are for sale. But we are strictly monitoring. The Court of Appeals, every month, there is a report that's submitted to the Supreme Court detailing the number of TROs that have been issued in such and such cases. And these are records. We can go back to that. Should there be a complaint that would arise, then these records will be able to help out in an honest-to-goodness investigation.
Okay, let me talk about the Supreme Court now, Justice.
Yes, Your Honor.
Where you are applying for a possible position due to the vacancy. Are you aware of the existence of any personal alliances among justices of the Supreme Court in terms of the manner of their voting on crucial cases before that?
Personal alliances? I'm not aware of any personal alliances, Your Honor. All I can say is that I know, because I know a number of the justices of the Supreme Court, because some of them were my colleagues in the trial court. So if you're talking about in that respect, whether or not this and that justice is allied to this, what I can say is that probably because of previous positions, they may have the same thinking with respect to what this or that matter. But as to whether they are personally allied, I am not aware of personal alliances, Your Honor. I can say prior positions, prior agrupations.
Do you think political considerations come into play in rendering judgments in the Supreme Court?
My answer to that, Your Honor, is a very frank statement that the Supreme Court, contrary to what many may believe, the Supreme Court is actually also a political organ of government. While standard theory says that the judiciary is apolitical, the Supreme Court, at least, because it's at the apex of the judiciary, the Supreme Court is not really apolitical. It's a political organ of government. In other words, it also processes things that are political. So my answer is the Supreme Court is a political organ, and therefore political processes come into play. But of course, the decision always the decision that comes out is always the one that is rendered with the Constitution as the standard. So all processes may come in, but the Constitution is the duty of the Supreme Court to ensure that all things that are undertaken meet the test of the Constitution. That's the final standard, Your Honor. It's the Supreme Court's duty.
All right, then, if you were in the Supreme Court, let's say you're lucky and fortunate enough to be appointed to the Supreme Court, and let's say the matter of, or the issue of Grace Poe's being a natural-born citizen is still in question, how would you vote on that matter?
To be very frank with you, Your Honor, at this point, I have only seen what have been published in the papers. It will be imprudent from a sitting member of the court, whether it be a lower court judge or appellate court, to publicly air his opinion on something that he has not studied very well. So if you are asking, Your Honor, how will I vote?
Your opinion, not necessarily on how they're going to vote, but on your opinion on whether or not, based on the exhaustive discussion that has been published in newspapers and media about the pros and cons,
yes.
What opinion have you formed regarding the issue of whether or not?
That is where the danger, Your Honor, of forming an opinion right now will come into play. Why? Because media right now is utilized by all parties concerned to advance their own opinion, advance their own positions. So for us to rely on the base of newspapers will be very, very imprudent. I have had my experience in this matter, Your Honor, and in my 8 years as a trial prosecutor, 8 years as a trial judge, I have seen that many things that appear in media, when brought to the court, vary very, very, very greatly. What is, for instance, presented as 10 kilos of shabu confiscated, when it's brought to trial court, it becomes 8 kilos. I mean, there are variations. That's why it's very difficult, Your Honor, to form an opinion on the basis of what one reads in the papers. This is not to say that the papers are not truthful, not at all. What I'm saying is, especially in a very political issue, whatever is brought out in the papers necessarily must be viewed as, with a second chance. with due respect, Your Honor, as much as I would like to make an opinion, I cannot do so because it will be imprudent. I do not have the facts before me to make such an intelligent opinion.
I respect your answer, Justice.
Thank you very much,
Thank
Your
you very
Honor.
much.
Thank you so much, Attorney Guevara. And now may I request Justice Lagman to continue.
Okay, actually, I don't intend to question Justice Bruselas anymore because we have interviewed him quite extensively since 2011.
Thank you very much, Your Honor.
And last time, he was nominated for the Supreme Court. Okay, I just want to be clarified of your statement to the question of Attorney Cayosa regarding your joint account with the
Yes.
members of your staff.
Yeah. No, just
I just want
the
to
three.
be clarified with
Only with three, Your Honors. Only with three members of my staff. My coterminous executive assistant, my son, my driver, and my utility. These accounts were opened way before we started the ATM payroll. This was opened about 6-7 years ago. The only reason why we had not been able, the suggestion is well taken that perhaps we should now disjoint the accounts. But we have not done that because there was no reason for it. It was very convenient. And as a matter of fact,
Kaya lang, people might
that's why, you know,
another
given that,
meaning to that.
and precisely, I think that observation was precisely based on that. That's why, Your Honor, I'll take the suggestion that tomorrow I'll have these three joint accounts disjointed. I will tell them to open their own accounts.
Oo nga. Buti na para
That's
to
right.
avoid
Yes, Your Honor.
suspicion or from anybody.
Yes,
Diba?
Yes, Your Honor. That's correct, Your Honor. But I thought that if the complaint were they were not being given their salary, then that's another matter because definitely do not do that. Your Honor. They would have come out and we have had cases like that in the court where employees have judged their superiors for withholding their salary. That's even an offense under the criminal code, Your Honor.
Oo nga. Pero mabuti na. It's better na
Yes, the only reason, as I said, to emphasize, Your Honor, that it was opened up way ahead. And we matagal na po yun eh. Hindi natin naakalain na it will become a problem. But now that it has been raised, it is
to
really
avoid any
prudent.
misconception.
That's right, Your Honor.
Okay, on that note, I have no question as I've stated, and I wish you luck.
Thank you very much, Your Honor. Thank you very much, Your Honor.
Okay.
Thank you so much, Justice Lagman. Justice Bruselas, you know, every complaint, every opposition reaching the JBC, we read. Every word we read. I have been reading the complaint of Attorney Malyari. The case that reached your court, the Court of Appeals, would you not consider it a sort of flip-flopping? Because in the beginning, it was P.J. Reyes who penned the decision
Yes, Your Honor.
in favor of Malyari, stating that the consignation with the trial court below is valid. That was the decision of P.J. Reyes. I read it.
The certiorari was denied, Your Honor.
Yes, but yes, you mentioned certiorari.
Yes, certiorari.
There was a decision of the RTC,
Yes. Judge Marigomen and
Judge Marigomen. It became final and executory. But the PNB raised the issue to your court via petition for certiorari under Rule 65,
Your Honor.
which I believe is very improper because a certiorari cannot be a substitute for a lost appeal.
That's correct, Your
Okay. On that point alone, as if there was already a flaw in the procedure. At any rate, P.J. Reyes decided the case.
Yes, Your
There
Honor.
was no grave abuse of discretion, and he upheld
Yes, Your
the
Honor.
consignation
Yes, Your
done below. But there was a motion for reconsideration,
That's
so there
correct.
was a division of 5.
Yes, Your Honor.
You were the ponente,
Yes, Your Honor.
and you reversed the decision of P.J.
The
Reyes.
position that I took, where the three others concurred in, was that certiorari is available. It is correct that certiorari cannot be a remedy for a lost appeal. But precisely, Your Honor, the point of the certiorari was, the movement was saying that appeal period had not yet prescribed. In fact, I remember the Nyquist rule, where a fresh period of 15 days is given. What happened below was that the trial court merely treated as a pro forma matter the appeal and dismissed the appeal perfunctorily. That was the point that was raised by the movement. And to us,
Because the decision has become final and executory. At any rate,
which is
let us not
contested.
discuss the merit anymore.
Yes.
Is that not an example of flip-flopping in the same division?
It is not a flip-flopping, Your Honor, because it was only flipped once.
Flip once.
If you say flip-flopping, it goes from one side to the other. But precisely, it was consistently decided against and we allowed certiorari. Why was this necessary? Because the court wanted the matter to be elevated on a full-blown appeal. Because what the movement was saying, what the other party was saying, is that the case should be killed at the below already. But we saw that the trial court, because the point was there will be no more avenue for the party below to have their appeal carried, seen by another court. That was the issue there. And on certiorari, we saw that should be brought up, not to the division, to the Court of Appeals.
But it was the fault of the PNB. Why did it not resort to appeal
I think they
within the 15-day period from the finality? Anyway,
I think they filed an MR, Your
anyway,
Honor.
I'm just discussing this to you.
Yes, Your Honor.
Just to be
Yes, Your
clarified.
Honor.
Anyway, I
Just
just
to
want
point-
to know.
Just to point out, Your Honor, please, that it is not flip-flopping because it was consistently ruled. In the second time that it was a division of 5 again, 4-1 again, I was not there anymore, and the others were there. I just was surprised. They sustained our position. In any event, Your
Anyway,
Honor,
the case is sub judice. It is
yes,
in the Supreme
45. It
Court.
should have been in Rule 45.
Just like the case of Grace Poe, sub judice.
Yes, Your Honor.
Well, you cannot give your opinion in the case of Grace Poe because according to you, you do not know the facts.
Yes.
You will only rely on the newspapers.
That's right, Your Honor.
But Justice, the facts are very clear. All right, define under the Constitution who are natural-born Filipino citizens.
You are talking about
Provision alone, you will know the answer.
You are talking about the case of Grace Poe, Your Honor.
Yes.
Well, under Article 4 of the Constitution, there's the definition of who are the citizens of the Philippines.
No, there is a
Natural-born.
specific provision defining who
Yes.
are natural-born
citizens.
Filipino citizens.
That's
You
what-
are referring to that provision, who are Filipino citizens. There is a specific provision defining who are Filipino citizens.
Yes, the provision.
Because, one of the rules of the JBC in determining the qualifications of applicants for judgeship or promotion is to test also their mastery of laws, rules, jurisprudence. So, my question is, who are
Natural-born citizens.
natural-born Filipino citizens as provided for by the Constitution?
Article 4, Section 4 says that natural-born citizens are those citizens who are citizens from birth without having to perfect or do anything to acquire or perfect their citizenship. These are deemed natural-born. Now, who else are natural-born? Those who elect, those who are born of mothers, those born...
No, I'm not asking that question. Only the natural-born. All right. Does Grace Poe fall under this definition?
Well,
What do you think?
I wanted to point out, Your Honor, that this other provision, who else are natural...
No, the issue is natural-born, hindi yung Filipino. Who are natural-born Filipino citizens? Because to aspire for the position of president, to aspire as senator, the aspirant must be a natural-born Filipino citizen.
That is correct.
Hindi lang Filipino citizen. That's why, under your definition, is Grace Poe a natural-born Filipino citizen?
Minus all the other facts, minus assuming that there are no other facts, it's clear that she's not a natural born. But, Your Honor, remember, there is now this ongoing DNA testing, so-called parents, factual in nature, which we are not aware, the court is not aware of. So hypothetically,
Si Foundling, she has admitted that.
but I was going to point out, Your Honor, the next provision, which says, children born before January 7, 1970.
No. Na hindi na yan natural-born.
No, Your
They
Honor,
are only Filipino citizens. Read the Constitution, I will show you. At any rate, let's put a stop to that. Sub judice yun, magagalit ang Supreme Court.
Your Honor, this is not hypothetical only, Your Honor, because I have the Constitution which says, Your Honor,
Hindi yan natural-born. The definition is, the following are Filipino citizens.
that is correct, Your Honor, and there is a provision,
Oh,
sir.
kung Filipino citizens
Those-
lang hindi natural-born,
Yes,
she is not qualified.
No, Your Honor, natural born, this is another natural born citizen. I hope, with due respect, Your Honor, I hope you will permit me just a minute, just 1 minute, Your Honor, which says, that same provision has this, it says, that next sentence, Your Honor, it says, those who elect Philippine citizenship in accordance with paragraph 3, section 1 hereof, shall be deemed natural-born citizen. So this is look at this is the same paragraph continuation of the sentence of section 2. Section 2 says, natural-born citizens are those who are citizens of the Philippines from birth without having to do anything to acquire or perfect their Philippine citizenship. Next sentence, those who elect Philippine citizenship in accordance with paragraph 3, section 1 above, hereof shall be deemed natural-born. And who are these? Above is those born before January 17, 1973, or Filipino mothers who elect Philippine citizenship upon reaching the age of majority. That's the other provision, Your Honor, that I was referring
Who is
to.
her mother?
That's why it's, Your Honor, it's a factual matter. That's why I wanted to say we are not yet able to answer that question.
And she resorted to DNA, so she performed something
That's why I said,
very
Your Honor,
clear.
that's why I said, Your Honor.
Anyway,
You cannot have
it's in the Supreme Court.
That's right, Your Honor.
I don't know what will be the decision. Anyway, that's my
Subject
opinion.
to factual.
So let us see how you develop or you will develop your concurring or dissent. If you were already a member of the Supreme Court at the time it decided the case of Chief Justice Corona, declaring that his appointment was constitutional. The ponente was Justice Bersamin. Will you concur or dissent? Reason.
Well, this is already a decided case, Your Honor, and to my recollection, the potential
Remember the cases of Villarta, Villanueva,
the two judges.
members of the judiciary.
Yes, the two judges.
And the appointment was really issued within the prohibited period.
It was the court departed from that. These two judges who were appointed.
No. The appointment of Chief Justice Corona
Yes,
was issued within the prohibited period.
That's why it was,
Within 2 months prior to the election and up to the end of the term of GMA. So will you concur or dissent?
the decision of in the case of Judge Corona reversed the decisions in the two judges who were also appointed.
My question is concurring ka ba or dissenting?
I go with the earlier decision of the two judges that who were appointed, but they were not allowed to sit because their appointments came within the prohibited period. That is my respectful position, Your Honor. And I with due respect to Justice Bersamin, I think
I agree with you. Next case. How about the case of Mayor Erac?
the case
The pardon, valid or not valid, legal or illegal?
I'm trying to
Will you concur or dissent?
I'm trying to recollect the facts. Because the nuance there, Your Honor, is that the way the executive order was crafted, it was crafted in such a way, in a very, 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 not deceitful, no, but in a very crafty way, that it would be susceptible of any decision. If we
There was a portion there that he is prohibited from exercising,
And at the
from holding any other government position.
but at the same time, yes,
he will enjoy his civil and
liberties.
political rights.
Yes, Your Honor. That's why it was craftily. If this last portion was not there, I would say that it should have been against. But because of this second part, I think the decision there
So you are concurring.
had enough basis, Your Honor. That is my respectful
You are
position.
concurring,
Had enough basis because of that, the way the order was crafted.
despite his personality,
It's not about the personality, Your Honor. It's about what has been written on.
despite his moral conduct.
The elections, Your Honor, will be the one to determine whether one is
Okay, last
qualified.
question. The U.S. Supreme Court decided only 100 or less than 100
90
cases
cases.
a year.
Yes, Your Honor.
That's a fact. Every year. We had discussion about this matter when we visited the Supreme Court of America. And
Yes, Your Honor.
we asked the justices, how do you do it? Okay, despite the fact of the number of appeal cases coming from the 50 states,
Yes, Your Honor.
yet
They are able to maintain.
imagine for 1 year, less than 100. And they told me sometimes only 87 or 85.
About
Do you
90.
think time will come when our Supreme Court, and considering that this is a very, very small country, will be able to attain that kind of achievement, or it will only remain a dream?
I think the reforms that are in place, Your Honor, will eventually lead to that. The reforms that are being undertaken. Well, right now we are trying to automate all courts. When you automate the courts, you'll be able to at once see the aging of cases. Because now, the cases are placed in index cards and papers, they're easily lost. But if you have automated procedures, all those concerned, all case processors will see how the cases are aging, and naturally you have to target first aging cases. Now, about the Supreme Court of the US, why is it that they were able to do it? I was told in our visit there that they really concentrate on certiorari petitions, and I think the way they do it is that amongst them, the 9 of them, they give out a list of what should be allowed and what should not be allowed. If it's in the list of the 9 of them, then it gets into the court. If it's not, then it's not even considered. So there's a mechanism for processing the thousands and thousands of cases that are brought up to the court. And I just wanted to point out, Your Honor, that the Supreme Court actually, if you look at the powers of the Supreme Court, all of the appeals that go to the Supreme Court are discretionary. They do not have actually, they cannot be forced to act on the case because many of their jurisdictions are concurrent with the Court of Appeals, with the RTCs. For instance, certiorari, prohibition, mandamus, quorum, these jurisdictions are originally in the Supreme Court but also concurrent with other courts. So there, I think the way to do it is to really ensure that certiorari petitions are reduced to a minimum. And how to do that? There are various ways. The US, they come up with a list.
In fact, Justice, we asked them, how do you do it? And then they said, this was the explanation.
Certiorari list.
Of course, we appoint the best lawyers in the country as the clerks. And then there is a group of lawyers who handle all these cases, who study these cases very well. And so that only few will be elevated to the bank. Oh, they have no division. At any rate, when I recommended this to Chief Justice Puno, he declined. It is not applicable in the Philippines because he doubts the integrity of lawyers. I don't know why.
That is one thing.
Last question, Justice. What cases from the Court of Appeals do you think should no longer be elevated to the Supreme Court?
If, Your Honor, please, I think most of the cases should stop at the Court of Appeals. And except, I'm talking only, Your Honor, we now have in People versus Mateo, the Supreme Court brought down to the Court of Appeals actions on criminal cases where the penalty is perpetua. So these ones, as I said, practically all cases, what should go up to the Supreme Court should only be certiorari petitions.
We sent even the cases concerning rapes, labor cases.
Yes, labor cases. Martin. Yes, Martin.
Agrarian. Therefore, like these cases, illegal detainer, simple theft.
That's why, Your Honor, even into possessions, I think this matter should no longer reach the Supreme Court.
That's why justices like you should submit to the Supreme Court this kind of recommendation to expedite.
Yes, Your Honor, I will at once convey this to our PJ.
Thank you very much, Justice. Good luck.
Your Honor. Thank you very much, Your Honor.
We can conduct a separate investigation, Attorney Mayari, but not here.
Thank you very much, Your Honors, for the opportunity to appear before the Honorable Judicial Member Council. Thank you. Maraming salamat po.